So good morning, everybody. Thank you. Well, good morning for those of you who are present here. For those of you who are joining us online, depends on your time zone. Good morning, good afternoon, or even good night. Welcome to the third conference of the TRICI-Law project, which has the title, The Practice of Interpretation in International Law, Unity, Diversity, and Evolution. First of all, I'd like to thank all the chairs, speakers who kindly decided to take some time off for what I know is extremely busy schedules for everybody, and honoring us by either being here and presenting live, but also the speakers who will be presenting online. We'd like, of course, to thank our keynote speaker as well, Judge Ziemele, who will be delivering the keynote speech shortly. And also, we'd like to thank the Greek ambassador, Katerina Guinea, for joining us today for this session. Thank you very much. And of course, we'd like to thank all the participants who joined both live and online. For those of you who are not familiar with our project, you can see it in the banner behind me. This is called aggressive marketing. We pronounce it TRICI-Law, despite that it is with a C. We've asked people from Cambridge and Oxford whether we can do that. They said because it's an abbreviation, we don't have to pronounce it TRICI. We can do whatever we want with it. So therefore, we pronounce it TRICI-Law just because it is a tricky area that we're researching. I spent, I think, a day trying to find that abbreviation when I was applying for the grant to make the words, the first letters, spell tricky. And then I realized that everybody used whatever letters they wanted. So that was 2 days of my time lost. But TRICI-Law stands for the Rules of Interpretation of Customary International Law. And the idea is that we're exploring the concept of whether, similarly to how treaties have rules of interpretation, whether we can find similar or perhaps different patterns of interpretation for customary international law. That it's not just about state practice and opinio juris, but once a rule has emerged, whether teleology or other methods of interpretation may become relevant for determining the content of the rule. So the project consists of 4 work packages. The first work package, spearheaded by Ms. Nina Mileva, who I think is in the back, deals with the theoretical possibility of interpretation of customary international law. Work package 2, spearheaded by Ms. Marina Fortuna, deals with the practice of interpretation of customary international law as evidenced by the case law of international courts and tribunals. Work package 3, in which this conference falls, is spearheaded by Dr. Sotirios Lekkas. And there we focus on comparing the patterns that we have found with generally accepted rules of interpretation of treaties or of unilateral acts. And I am kind of the passepartout, jumping from one work package to the other, taking all the benefits of the research unashamedly so. And also for the final work package, which is the synthesis package, trying to merge everything into a coherent and maybe meaningful contribution. So, having said that, I will now yield the floor to Sotirios Lekkas, who was the main and is the main driving force behind this conference. So, Sotirios.
Hi, good morning. So welcome. Thank you, Panos, for the kind introduction. I don't know if I am the driving force or the mouthpiece of this conference. So welcome. Thank you very much for joining us today. To all the speakers and all the participants at home. I would like to also, give a shout out to Tatiana Spike-Belanova, who was, I think, the true driving force behind this conference. She is our project manager. So I will just say a few words about the theme of the conference, and then I will go on with a few formalities. It's not about parking, it's just something else. So the theme of the conference. So essentially, I hope for the next few days, we'll be discussing the general idea, what are the rules and methods of interpretation of international law, which is quite vague, but also an interesting question. Are there rules of interpretation that apply to rules other than treaties? And how are they different to treaty interpretation? For instance, are there rules of interpretation of customary international law which are tricky? But also for other sources, general principles of law, jus cogens, international crimes, human rights, acts of international organizations, or unilateral state acts. So is there any reason for specific rules or specific acts to be interpreted in different way? So more fundamentally, we will also try to look a little bit into what is the law and interpretation involving to. Is it limited to treaty interpretation and we are even starting to forget about that? Or do we need new rules that address new needs? Or do we need special rules that address the needs of each specific area? Now, does it matter? I would say it does. And for me, it's mostly for two reasons. First of all, there are some criticisms leveled against international adjudicators and adjudication in general. So for instance, there is a paralysis of the WTO appellate body, or the reconsideration of ISDS in the context of UNCITRAL. So in this context, we can see these criticisms being leveled, which are to a certain extent political, but is there a legal way to assess whether adjudicators are doing it right or are doing it wrong? And also for me, it does matter because reality tends to defy distinctions between custom, treaty, or human rights, international criminal law, or international environmental law. The same act in certain situations can transcend, our very own classifications and can fall under quite different fields of law. And it could be quite interesting to think if there is a shared method, a shared culture amongst international lawyers. And to this end, we hope that we have assembled all kinds of expertise in human rights, in international environmental law, in the law of the sea, international criminal law, and international economic law. During the 2 days, we will have, of course, the keynote by Judge Ineta Ziemele, and we also have 5 panels consisting of experts in specific fields: human rights, environment and law of the sea, international criminal law, international economic law, and the law of international organizations and sources. Chairs will introduce the speakers of each panel. But now we are in the tricky situation where we need to introduce the chairs. So our first chair is Judge Hilary Charlesworth. She is a judge at the International Court of Justice and a scholar on the theory of international law. She's also a member of the curatorium of the Hague Academy of International Law and an associate member of the Institut de Droit International. She previously held chairs of international law at Melbourne Law School and the Australian National University. Judge Lisbeth Lynsat will be chairing our second panel on international environment and international law of the sea. Judge Elizabeth Lynsat is a judge at the International Tribunal of the Law of the Sea and distinguished scholar on the practice of international law. Quite literally, she has the chair of practice of international law at Maastricht University. Prior to that, she served at the Ministry of Foreign Affairs of the Netherlands at the Legal Service, and she headed the International Law Department. Our next chair will be Professor Larissa van den Herik. She will be chairing the panel on sources. She's a professor of public international law here at Leiden University. She's also chairing the advisory committee of public international law issues to the Dutch government. Professor van den Herik has written extensively on peace and security, sanctions, terrorism, and international criminal law. Our next chair, chairing the panel on international criminal law, is Professor Carsten Stan. Professor Carsten Stan is Professor of International Criminal Law and Global Justice at Leiden University, and Professor of Public International Law and International Criminal Justice at Queen's University Belfast. He has previously held positions in academic institutions in Germany and the UK, and he has also served at the legal department of the International Criminal Court. And our last chair, she will be chairing the panel on international economic law, is Dr. Anna Alexandra Marhold. She is assistant professor in the Grotius Center for International Legal Studies at Leiden University. She's also a member of the Executive Council of the Society of International Economic Law. She specializes in international economic law with a particular focus on international trade law and the intersection of energy and environmental regulation. So I hope you had enough of me. So I give the floor to Panos again to introduce our keynote speaker.
So thank you, Sotirios. We've reversed the order. So the chairs are going to introduce the speakers. Sotirios introduced the chairs, and we now have to introduce, we like to introduce the keynote speaker. Before I do that, because Sotirios gave a shout out, and rightly so, to Tatiana, and I hang my head in shame as well. But we also forgot to mention also Mr. Konrad Turnbull as well, the mustachioed guy at the back, who's the person, the puppet master responsible for taking care of all issues relating to audiovisual, plus our colleagues from Hotel des Indes who do that. I don't think we've forgotten anyone apart from our keynote speaker now, finally. So with great pleasure, I'd like to introduce Her Excellency Judge Ineta Ziemele, who has an extensive CV, but I won't go through it in extenso because we're more interested in hearing what you have to say. I'll simply refer to her career in the judiciary, which started in 2005 when she was appointed as judge at the European Court of Human Rights in Strasbourg, where she was also held the position of president of chamber until 2014. Then she was appointed as judge at the Constitutional Court in Latvia in 2015, where she served also as president from 2017 to 2020. And to add to that, she is currently serving as a judge at the Court of Justice of the European Union as of 6 October 2022. So I think Judge Ziemele is the ideal person to talk about the topic of our conference. So, Your Excellency.
Good morning, ladies and gentlemen, and it's really a great pleasure. It's been, I realized, with all of the crises that we have, it's been really quite a while since actually I have had a pleasure to get out of the judiciary and to address the colleagues, the audience that I have always considered myself being part, and that I've always felt particularly comfortable with. Now, so many thanks once again for this kind invitation, and I'm happy I really made an effort to squeeze in the journey from Luxembourg to The Hague. Now, I will deceive you, because I will not discover anything new as far as your project is concerned. You are by far, ahead of anything that is happening in the courts that I know, as far as interpretation and application of customary international law or general principles of international law is concerned. And it is therefore that I find your project extremely important. And that was indeed the major reason why I tried to make an effort to come and listen to the conference, which I will for the rest of the day. Now, in my talk, I hope to transmit to you in a way conservatism that reigns in the courts. And I really think that is so, but probably based on what I'm going to tell you, you will be able to sort of gather for yourselves one of the questions that you both identified, which was whether the judiciary, speaking of judicialization of international relations, whether the judiciary really do it right as far as they do it, as far as general international law is concerned. And so I will, the reason, there is another reason, not only the pandemics and the fact that we haven't really seen each other, but there is another reason why I am particularly interested in your project and in this conference is the fact that naturally the very issue of interpretation of international law has truly preoccupied me in all three courts that I know. And well, I have in my capacities as judge in the Strasbourg court and then Constitutional Court, and now in the Court of Justice, naturally I have my own view as to how these courts should look at international law rules. And I have been trying sort of to explain that through separate opinions where that is available. And based on all of that experience, let me sort of sketch out for you how I actually see the matter. And I would like to start with the context, which I think is very important. So first, international law, like any other legal system, must ensure legal certainty. I've always been of the opinion that it is especially important for international law in light of the constant criticism advanced towards the nature, as we know, of this legal system. And one of the key tools to ensure legal certainty is a consistent and coherent application of rules based on a method of interpretation, where that method serves as the backbone of a judgment. The legal system and an act of application of a specific rule gain persuasiveness and legitimacy where the use of the method of interpretation of a rule is consistent from one case to another. Now, judges are the guarantors of the resilience of law in the sense that it is in their power to ensure its impartial and uniform application, which in turn counters against allegations of inefficiency or bias in a system of law. All these considerations play towards at least a perception of the rule of law in a legal system. And it is therefore that the general rule of interpretation of international law, to me, is a central element in what we call the international rule of law. And I cite here with a number of arguments to the same extent advanced in the legal scholarship. I think that all of the actors, including the judges and the courts of the legal system, of international legal system, need to be acutely aware well, of this broader context. Now, in practice, this, of course, the outlining of such a paradigm, of such a context is easy. However, in practice, it is more complicated. And there are multiple factors that, of course, affect the consistency and coherence of adjudication as different courts sort of do that on daily basis. Now, I would also like to refer here to what I believe is a thought that Martti Koskaniemi at some point said about international law, that he pointed out that it has become a discipline for a narrow circle of lawyers, and it is an element of a broader context within which I see application of international law by the courts. I must say that, coming from the country that I'm coming, I'm Latvian, and given the history of the Baltic states and what we have been dealing with also since the restoration of the independence, it is true that I have felt this and experienced this tension between, the politics in international relations and sort of the attempts of rules to somehow mitigate the politics and the big powers. And that indeed, unfortunately, is a reality. It is true that judicialization of international law has made the rule of law sort of discourse in world affairs more visible. That is clearly felt now in the 21st century. But I must say that the tension between politics and law, as we know, is still considerable. And I think we still have a very long way to go to make sure that the rule of law, through its consistent application, in fact, kind of sort of puts the politics within a certain more foreseeable context. So there we are. And I am absolutely convinced that coherence and consistency among the courts as to their application of international law is undoubtedly helpful to making international law more resilient and also more legitimate, as it were. Now, I shall now present the practice of the two European courts, which will allow me to share my analysis of the consistency or particularity of the use of a general rule of interpretation. That's what I would like to focus on. And I think it is helpful to begin rather with the conclusion so that you would immediately sort of see where my examples, sort of how they fit into my conclusion. And the conclusion actually is the following: the nature of the treaties that both European courts are entrusted with interpreting based on the object and purpose of a treaty, as disclosed by the courts, has a defining influence on the interpretative work of the court concerned. And that I really say, based on my in-house, so to say, experience. Now, it seems a rather simple and straightforward kind of conclusion, but experience actually shows, indeed, in practice, it is a very complicated matter. Now, there has been, it's been pointed out by the leaders of the project, that there has been a fair amount of misunderstanding related to how the courts apply the object and purpose criterion, as well as good faith criterion. And I would almost like to say that in international law debate and analysis of what the courts, for example, do, I sometimes have gotten a feeling that we get lost in translation also in absolutely good faith. Now, so I will speak about the object and purpose of the leading European treaties and exemplify how the two courts understand them, what conclusions have been drawn, and you will see how the other sources of international law actually, come into what the courts do. So, of course, let me first begin with the European Court of Human Rights, and the Court of Justice will forgive me that it will be number 2. Now, since its early days, and in fact, I would like to make a very important point. When we have such a development of case law, and of course, in both European courts, the case law develops extremely rapidly. And I know that it is very difficult to follow it and sort of to understand what to look at. The point I really would like to make from practice, you always have to go back to the beginnings. Because it is there that the bottom line sort of identity of the court has been identified. And it is the later case law, the thing that you find is, has the court had the courage or necessity, a big necessity, to change something about the beginnings, about the roots? So therefore, do not be surprised. I go back to the classics. Now, so the court, as you know, since the early days, has maintained that its authority to interpret proceeds from an international treaty with a special legal character, a law-making or normative treaty, which has a particular objective and purpose, the protection of human rights in Europe. And this pronouncement goes back to, 70s, where, and I quote, Ireland versus the United Kingdom, the court clearly said, unlike international treaties of the classic kind, the convention comprises more than mere reciprocal engagements between contracting states. It creates over and above a network of mutual bilateral undertakings, objective obligations, which in the words of the preamble, benefit from a collective enforcement. The court, in effect, affirms the erga omnes character of the convention. That's the identity. That is the identity of the European, of the convention system. Hasn't changed. Now, what is interesting, I would say that one of the most powerful consequences that the European Court of Human Rights actually drew from the special character of the convention goes back to Balilos and Loisedo jurisprudence. Now, I think we all know why I'm actually making that point. As you know, just to recall, in the course of the case, the court had to determine whether Turkey had the right to territorially limit its acceptance of the competence of the then Commission and the court by submitting a declaration that excluded its responsibility of the possible human rights violations in the territory of Northern Cyprus. And so the court, as you know, declared this declaration reservation was invalid and set it aside. Now, how did the court arrive to that conclusion? Now, what I would like to underline is that the court followed the general rule of interpretation of treaties and was very clear about it in point 73 of the judgment on preliminary objections to determine whether the contracting parties may impose restrictions on their acceptance of the competence of the Commission and the court. The court will seek to ascertain the ordinary meaning to be given to the terms of these provisions in their context and in the light of their object and purpose. And it shall also take into account, together with the context, any subsequent practice in the application of the treaty, which establishes the agreement of the parties regarding its interpretation. Now, so far, very clear, we know where we are. However, the assertion above is from, as I said, paragraph 73 of the judgment. But several other statements precede this point. Paragraph 72 affirms that, in addition to the object and purpose, the convention of the convention as an instrument for the protection of individual human rights, that of individual human beings, requires that its provisions be interpreted and applied so as to make its safeguards practical and effective. We move on, another point before, that the convention is a living instrument. That's where we are, which must be interpreted in the light of present-day conditions, is firmly rooted in the court's case law. And such an approach, in the court's view, is not confined to the substantive provisions of the convention, but also applies to those provisions which govern the operation of the convention's enforcement machinery. It follows that these provisions cannot be interpreted solely in accordance with the intentions of the authors as expressed more than 40 years ago. We sometimes really need to go back to these original texts and reflect again on what sort of, what basis has been put, for example, in this system. And subsequently, the court says, even if at the time of the ratification of the convention, such a reservation was permissible, such evidence could not be decisive at the time the court adjudicates. Now, this reasoning can be genuinely understood to mean that there are additional principles to the criterion of the object and purpose of the convention. And such an understanding of the court's case law has afterwards indeed emanated from the court itself, as well as from the legal scholarship. Now, it has been suggested that notions as living instruments, European consensus, the practical and effective protection of individual rights on their terms do not square well with Article 31 of the Vienna Convention on the Law of Treaties. However, when really examined in detail and in their proper context, one begins to wonder whether there is more unity than divergence after all. Now, I will not be able to answer that question, but I would like simply to put a thought in your minds to reflect on it and to go back to some beginnings. Now, the above Loisedo passages bring up the element of time and the special object and purpose of the convention, and contrasts these ideas against state consent expressed 40 years earlier. None of that, in my view, is new to general international law. I refer to the ICJ's Namibia advisory opinion on the mandate system, determined as a sacred trust for civilization, I quote, and assumed that content of the mandate was evolutionary and not static. This Namibia dicta is, in my mind, one of the most important expressions of the intertemporal rule of international law. And it does confirm with the conclusion reached in the work of the International Law Commission on the Vienna Convention. And I will just quote at the time the Areshaga said as follows. It's also very pertinent to keep in mind. The intention of the parties should be controlling. And there seemed to be two possibilities as far as the intention was concerned. Either they had meant to incorporate in the treaty some legal concepts that would remain unchanged, or if they had no such intention, the legal concept might be subject to change and would then have to be interpreted not only in the context of the instrument, but also within the framework of the entire legal order to which they belong. Now, in the absence of the intent of the parties to the ECHR, to cut it in stone, as it were, it is by definition a living instrument, since its object is real human relations, which are evolutive in character, And its purpose is to ensure their effective protection over time. I think these observations are helpful in explaining the changes in the Convention's material content over time. Now, there is still a question, of course, a very important question that I began with, as to the proper interpretation that detects this evolution. And I will come back to that in a minute. But I would like to address the consequences that the court drew in the Belilos-Loizido case law concerning its competence to examine the compatibility of reservations to the convention with its object and purpose. And, you know, also the consequences that the court drew, because there is a tiny problem. We can't automatically presume that intertemporal rule would explain and substantiate what could be seen as expansion of the competence of the court or any treaty monitoring body. So there is that tension in the air that we have. And I'm not sure I have been able myself to explain it, but I mean, we are aware of this difficulty that we had in general international law, which was eventually channeled in a form of a question through the International Law Commission and the work of ILC on the reservations to treaties. And it seems that in the guidelines of 2011, the International Law Commission sort of more or less dealt with all of the misunderstandings between the human rights bodies, notably, and the court, and the sort of the general international law public. And as you remember, in the guidelines, actually, the solution really came when sort of the special rapporteur, Alain Pellet, took an inspiration in the Vienna Conference on Human Rights in 1993, and the definition given to human rights in the final document of the Vienna Conference. So you will recall that the ILC said that for those treaties, especially human rights treaties, which as their object, human rights treaties form a set of interdependent, indivisible, and interrelated rights and obligations. And because of this particularity, the ILC was ready to see that the competence of the courts, human rights courts, and the monitoring bodies has its particular nature. So the reservations to such treaties, also environmental treaties, can be assessed and should be assessed in the context of the treaty and set aside. Now, I believe what the ILC did, it really explained the principle of good faith when discussing the nature of reservations with regard to human rights treaties. And what it says, if you upset the treaty in its indivisibility, you actually have not entered into this treaty in a good faith. And therefore, by definition, such a reservation is outside the scope of that treaty. So I would therefore say, when a court or a monitoring body identifies a resolution, a reservation which is contrary to a normative treaty, it has a competence to say so, and it does not upset the very idea of state consent, nor does it arbitrarily extend the powers of courts or monitoring bodies. Yeah, so that would be my take on this friction that we might feel as far as passage of time, interpretation with an evolutive approach of human rights treaties and the competence of the monitoring bodies. But what is very important to also keep in mind that, for example, in the Loisidó case law, you can actually take the preliminary objections judgment as a textbook example, how the court uses the general rule of interpretation. It's, you know, you can't write better in a textbook. You just have to quote the particular judgment. Now, however, I'm simply going also rather rapidly through because I realized that my time is rather running out. Okay, whatever legal consequences the courts draw within their competence when confronted with different legal questions, the clarity and consistency of the method underpinning the reasoning, therefore, cannot be underestimated. Even if you think that the court has sort of enlarged its competence, it is still matters whether you have a school book example, how the court has arrived there. So that's really a very important point. And then, of course, we enter into another tension that I have already hinted. The tension that comes with teleological interpretation, to which the criterion of the object and purpose of a treaty invites the interpreter to resort. In a way, is inevitable, and indeed, even more so with time. I mean, the treaty sort of lives, hopefully, for a very long time. And, you know, we will have to deal with the fact that 40 years ago, somebody thought something else. That is the reality that the judges are confronted with. Now, I would like to quote my own professor, James Crawford, because I think he really put it very well, the difficulty we have with teleological interpretation. And in the last edition of which he supervised, of the Brownlee's Principles of Public International Law, he said, the reason we have the difficulty is with teleological interpretation is that this may involve a judicial implementation of purposes in a fashion not contemplated by the parties. Teleological approach has many pitfalls, not least its overt legislative character. Indeed, the evolutive or progressive interpretation is closely linked with the teleological approach and is very much a part of the European Court of Human Rights toolbox. James Crawford, indeed, with reference to the European Court of Human Rights, cautioned, noting that the court has preferred an effective and evolutionary approach in applying the convention. And he sort of drew a certain interim conclusion or observation, saying that this approach suffers the defect that the ILC did not adopt the principle, considering that as a matter of existing law, it was reflected sufficiently in the doctrine of interpretation in good faith, in accordance with the ordinary meaning of the text. And of course, again, you have all of these pros and cons, and in a way, you have a feeling that it is a bit of a vicious circle. Now, indeed, as the example of the Loisidó case law shows, the European Court of Human Rights disclosed what, in terms of good faith, the acceptance of the competence of the Commission and the court by Turkey meant. That's how the court understood what Turkey, in good faith, should have done when entering the convention. The difficulty is that in doing so, it indeed resorted, as I pointed out, to the notions of living instrument and the principle of effective rights protection, and that friction between competence and material scope of the convention, we indeed have it. And the court clearly placed itself on the path of evolutive interpretation of the convention. Now, that is an identity element of the European Convention system since the Tyrer. The court has been very, very clear that it will look into the developments and commonly accepted standards in the member states of the Council of Europe. It's been for decades there. It's part of the fabric of human rights protection in Europe. And, you know, the only way for us really is to make it as sound as possible, this approach, both as judges, but also as scholars. Yeah. Now, because of course, what you see in scholarship is a lot of criticism of evolutive interpretation. You see a lot of criticism of what is part of it, European consensus. I mean, there are books written by you where you say that the origins of these concepts are very unclear, that leads to casuistic case law. The ILC, in its work on fragmentation, has mentioned that as one of the examples of fragmentation within general international law. But of course, there is this risk of overshadowing state consent as the basis of the legal system that we are dealing with today. But probably above all, for me, it is the question that unless we are very, very certain on these methods of interpretation, and we have solidly explained them and based them in the legal system, we have an issue with legitimacy. With the legitimacy of particular sort of, you know, exercises of adjudication. Now, I have myself also in the scholarly work dealt with the matter of evolutive interpretation, and in particular, a European consensus as an element on the basis of which that interpretation is carried out by the European Court of Human Rights. I will not go into the details of my own sort of findings in this, but just to summarize, I should say, as far as the case law of the European Court of Human Rights is concerned, you have a bit of two groups of case law. You have those cases, for example, Hassan versus the United Kingdom, where you see that the court has clearly based itself on Article 31(3)(b), which is a very rare occasion in the Human Rights Court's practice, and has really gone into an effort to assess subsequent practice. In fact, to understand how to interpret Article 5 of the European Convention on Human Rights. You know that Article 5, from a grammatical point of view, is very clear. It's actually, it is just these exceptions listed in the article to the freedom of liberty. The question in Hassan case was whether you know, occupying power that exercises effective control in Iraq had the right to deprive of liberty a civilian person, but within, of course, an occupation context, so within a context where you would follow international humanitarian law guidelines. And the question was, how do you marry European Convention on Human Rights, Article 5, and international humanitarian law? And it is here that the court uses as a method 31(3)(b). Fine as far as it goes, but you have also case law where there is an assessment of subsequent practice, but that goes into a method called European consensus, without necessarily referring to Article 31(3)(b) or (c). So you do have these groups, and how each time the court chooses that maybe does not transpire very easily. The dicta of Demir and Baykara, as far as Article 31.3 B and C is concerned, yeah, is also, I think, subject that for further discussion. And I just quote it for you so that we know where we are. The court may not be too concerned as to whether the state has ratified the treaty or whether the common domestic practices emerge specifically in the application of the European Convention, as the wording of Article 31.3 would indicate. The court is interested in seeing the common developments and trends relevant to the scope of the convention without necessarily identifying the binding character of these developments and practices. In other words, while Article 31 of the Vienna Convention offers a frame of reference for the court as such, the court has followed the method of interpretation with certain flexibility. That is my sort of take on the court's practice. And it actually ties in with what the special rapporteur, now Judge Georg Nolte, has noted in his work on subsequent practice, where he said in one of his reports, the European Court of Human Rights mostly limits itself to broad and sometimes rough comparative assessments of the domestic legislation or international positions adopted by states. But he does admit that the character of certain rights sometimes speaks in favor of taking less specific practice into account. Now, indeed, you already see, and the court has admitted itself, that it doesn't really often stick to maybe a kind of very concrete, sometimes even narrow legalistic assessments of state practice, of relevant state practice. It is guided and carried by the object and purpose, by the special object and purpose of the convention. Now, whether that in itself means that the European Court of Human Rights has developed its own independent method of interpretation and has therefore, went into conceptualizing diversity in the practice of international law. My own take is no. In fact, irrespective of some of the language, and on the language, the courts can improve endlessly. I can tell you that. It's never a ready judgment. Actually, coming out of deliberations, you always think this is, in this point, it could have been still better expressed. And it's a compromise, of course, as well. But overall, the court has stayed within the unity aspect of the practice, but has indeed taken a very good care of the particular nature of the system that it has to protect. And I would say, so the issue is not really, speaking of unity, diversity, and evolution, the issue is not with a method or a general rule of interpretation of a treaty, but the issue is, as in fact, again, James Crawford used to say, that the doctrine of ordinary meaning involves only a presumption. A meaning other than ordinary meaning may be established, but the proponent of the special meaning has a burden of proof. And so we have come a circle, and we come back to the ordinary meaning, and we come back to the principle of good faith. So, as far as the Court of Justice is concerned, now, the Court of Justice, similar to national constitutional courts, has a somewhat more complex task a more complex relationship, if you can imagine that, with the whole issue of the application of international law. The reason for that is, well, the very history of the European Union, I should say. And today I could sort of qualify that the Court of Justice stands at the crossroads between international and European constitutional law. And that was, again, already foreseen in 1963 in Van Genden-Loss, when that very case, in fact, it was interesting that it was this case, I agree with Professor Weiler, who said that Van Genden-Loss shaped the legal order. Not only shaped the legal order, it constituted that order, a new legal order of international law, yes, based on international law, but by now with major constitutional law, constitutional law consequences. Now, the Court of Justice has ever since, as we know, attempted to live up to the definition provided by Van Genden-Loss, and has tried to indeed delineate what is new about this autonomous legal order, as the court relentlessly emphasizes. Such general principles of EU law as autonomy, primacy, effectiveness, equivalence, mutual trust, loyal cooperation, which sources are both legislative and judicial. That is also rather interesting. And they do determine this particular legal order as autonomous, in fact, constitutional legal order. Now, the case law of the Court of Justice confirms the dual character of the EU legal order. And depending on this dual character, the relationship with international law, of course, is different from what we know, for example, from the European Convention on Human Rights. For example, when international agreement enters into force within the Union, like in most constitutional legal orders, it becomes integral part of the Union law. Now, secondly, when international agreement, in order to be functional, you typically need to also adopt secondary acts to make an international treaty applicable within the Union law. In fact, all of the secondary acts have to comply with international agreements entered into by the Union. So you have already the hierarchy in that legal system. You have the hierarchy of sources of law, where international treaties come right after the primary law, which is the Treaty on European Union and Treaty on the Functioning of the European Union. All of the international agreements have to comply with the Constitution, I should say, with both treaties of the European Union. Now, what is also true, that the court has emphasized that the Union and the treaties it enters into must comply, and that's clarified over last years. It wasn't so clear, let's say, some time ago, but it must comply with general and customary international law. You might remember that in the 90s, there was a big discussion where what happens to customary international law within the EU legal system. Now the Court of Justice has really clarified the matter, and I'll come to a specific example on that. Now, Article 3.5 of the Treaty on European Union is extremely important for the relationship between the EU legal order and international law. According to that article, European Union contributes to the strict observance and development of international law. And in its practice, it has applied the principle, for example, of right of self-determination directly within the EU legal order in the Western Sahara cases or case law. And of course, what is interesting is the fact that the Court of Justice, when confronted with the issue of the interpretation of international treaties, what it does not use its methods of interpretation, because the Court of Justice has its own methods of interpretation, which are similar to what we know in basically in the German legal system, I should say, and classically in the others. So when it comes to the interpretation of international treaties, the Court of Justice resorts to the Vienna Convention on the Law of Treaties, Article 31. Now, furthermore, the European Union law, based on the Court of Justice interpretation, also contains a principle of harmonious interpretation between the EU law and international law. So even though in the hierarchy of sources, international treaties indeed come only in the second position, I should say, nevertheless, when the court is confronted with the interpretation of the treaties on European Union, etc., it will be guided by the principle of harmonious interpretation. That also sort of is kind of in the backs of the mind. And moreover, the court has also developed in ATA judgment the principle of invocability of an international treaty in front of the European courts. Any private person can invoke an international agreement and argue incompatibility of the secondary act with international agreement if union is bound by an international agreement, if the nature and the structure of the international agreement allows an examination of the validity of the secondary act, and the provisions of the treaty which are relied upon for the purposes of examining the validity of such a secondary act appear to be unconditional and sufficiently precise. Basically, it is the concept of self-executing international treaty which the court has taken and brought into the EU legal system. So you can see that international law actually rather genuinely enters the fabric of the European Union law. But even more so, even where the court has determined, like as far as Aarhus Convention is concerned, that the Aarhus Convention does not have direct applicability as a matter of EU law. In the Slovak Brown Bear case, the court said that the national courts have to comply with the Aarhus Convention as a matter of their international obligations and as a matter of the EU law on the protection of environment. And so what you see here is, in fact, that the European Union comes in as a very strong supporter of the effectiveness of international law, given a particular character of the relationships between the national courts in the EU member states and the Court of Justice, because that relationship, of course, is very unique. We don't have any other similar relationship around the world through the direct dialogue, procedural dialogue between national courts and the Court of Justice. So these are the examples that tell you that on the surface of it, at least, EU legal order takes a monist approach to international law. However, there are other examples that may, in fact, jeopardize that understanding. And of course, I will refer to Kadi, Opinion 213, and I will refer to Acmea. Now, let me maybe explain a little bit how I see these three examples, because indeed there has been an argument and is an argument that in these three cases, the Court of Justice has probably jeopardized some legal constructs of international law, and certainly has not made life easy for investment settlement dispute, for the European Convention on Human Rights, for the human rights architecture in Europe. Now, the explanation of these three cases derives from the nature of the European Union legal order as a constitutional order, which provides for higher protection of fundamental rights and the European form of governance. The principles of rule of law, as you know, being very central to the very identity of the EU law, the separation of powers. And the CADI is to be explained by the fact that, yes, the Court of Justice absolutely agrees that UN Security Council should be involved when it comes to deciding on the sanctions, etc. But the point made in the European Union is that it cannot trump the right to fair trial. And so that's a value, really a value debate here. As far as opinion 213 is concerned, I still hope that, I hope there is a hope for a common human rights architecture in Europe, because it doesn't help, you know, these parallel developments in human rights and fundamental rights protection, and they are really parallel. I have so many examples where we go parallelly with the Strasbourg court. But the reason opinion 213 was the way it was is the following, that the Court of Justice was really concerned that through the door that it doesn't have authority to control, it will be faced with the interpretation of the EU law in the field of fundamental rights, well, precisely where it doesn't have a final say on what the EU law is. Acmea is slightly different, but along the same logic. Acmea meant that according to Article 267 of the Treaty on the Functioning of the European Union, all the courts applying within EU system may one day be confronted with the application of the EU law, given, you know, the abundancy of EU legislation. And so therefore, all of the courts have to be in the system where, based on 267, they can ask for a preliminary opinion based on the criteria of the EU law for the interpretation of a particular EU law provision. And the particular sort of dispute settlement body based in Frankfurt, I believe, was not in the system of European judiciary. Again, I would say this is very much a constitutional law approach in a sort of from a systemic point of view. And finally, my final example is really, I think, one of the most prominent examples where European Union and the Court of Justice in particular engages with international law. And that's the agreements, European Union agreements with Morocco. And that is the very question of the status of Western Sahara. And I think one of the very interesting sort of proceedings was the case that started in the General Court, where the General Court annulled the association agreement between EU and Morocco, saying that it is contrary to the right to self-determination because the treaty did not mention that Western Sahara is not part of that treaty. As you know, the Court of Justice overturned the General Court's judgment. In fact, really basing its reasoning, all of its reasoning, on international law, saying that, in very simple terms, that the European Union could not enter into such an agreement which would be against the right to self-determination of the people of Western Sahara. The Court of Justice did refer to the United Nations Charter. It did refer to the ICJ advisory opinion on Western Sahara. It actually used as a backbone of the judgment Article 31(3)(c), but also other relevant articles of the Vienna Convention on the Law of Treaties. It was pertinent to refer to Article 29. It was pertinent to discuss the whole notion of a third party, uninformed third party, that it becomes a party to the agreement that it even didn't know about. And so it is based on such an analysis that then the Court of Justice moves into what is known in constitutional law as the principle of rational legislator. And basically you have, a bouquet of relevant international law rules and the constitutional law principle, where the Court of Justice says, well, of course, we have a faith that the EU legislator is rational and would not go under the carpet against international law. And it is therefore that Western Sahara is not the territory of Morocco in the sense of the association agreement between Morocco and the European Union. That may be, of course, the judgments of the Court of Justice have their own particular style, and they are different from maybe what we know also in terms of, judgments of other international courts. And that has to do with the fact that the Court of Justice, of course, merely in majority of the cases, interprets EU law. There are direct actions, and that's again another methodology for the construction of the judgment. But it has to do with the particularity of the functioning of the European Union as such. So now, having then given you this, to my mind, one of the most interesting examples of the Court of Justice engagement with international law in the one of the Western Sahara case, but there are several around this issue. Let me conclude, and I think it's about time I conclude indeed. Now, so I will finish by reiterating what I started with, that the nature of a treaty or a legal order determined by the legal relations that this treaty or legal order is meant to regulate impacts in important ways the use of a general rule of interpretation of a treaty, and therefore, the resort to what interests you in your project, state practice and other rules of international law. And that is indeed very important to keep in mind when for any sort of academic research purposes. It is the object and purpose of a treaty that, and you saw in the European context, has a major impact on the, in fact, on the way that particular treaty or legal order evolves. Now, that said, it already shows that there is a risk of introducing what we could call as uncertainties, depending on whether you deal with human rights, depending on whether you deal with European Union law or any other area you will be discussing during the conference. At the same time, I can tell you that from my experience, that the states are very acutely aware of what is going on in all of these adjudication moments in our in our world, and the states really, the governments really follow what the courts do. By now, we are in a stage of development where indeed there is an understanding, and we've seen it time and again, there is an understanding of the role and a major impact that all of the courts have on world affairs, on politics, if you want. It is true, the courts also have experienced that if it is perceived that there has been too much liberty, that may backfire, and it has backfired. Yeah. So I think what is extremely important is that the judges going into the international courts, sort of working in international courts, because not everybody has an international law necessarily formation, but that there is an awareness that state consent is one of the pillars, still is, on the one hand, and on the other hand is the judicial authority as one of the main values in the world order that we are trying to construct. And that it is necessary to look at these two major elements in their dialectics. And it is this awareness that we really need to, to work on and to continue explain through the doctrinal writings, as well as in internal discussions among the judges. And I personally have a major faith in this dialectics, because I believe in dialectics as generating, new ideas anyway, provided all parties concerned approach it in good faith. Thank you very much.
Thank you very much, Judge Ziemele, for this tour de force through the interpretative practice of two international courts and tribunals, peppered with several references to other courts and tribunals as well, and bodies. Let me ease your mind that your secret is safe with us, that you start, despite your current position, you started with the reference to the European Court of Human Rights, but I cannot guarantee that it will remain with us because of the recordings. So I don't want to abuse, although I do have a lot of questions, I don't want to abuse my position as not chair, but introducing a US keynote speaker. So I'll open it to the floor for any questions that you might have, and also to the people online. So are there any brief questions before we adjourn for a coffee break?
Maybe one brief question. Marcel.
Marcel.
I need to sorry. Yes, just maybe a brief reflection or question. Marcel Brus, University of Groningen, on this very inspiring speech. Thank you for that. because sometimes I feel as a general international lawyer a bit lost in the details of the discussions about interpretation. And so certainly when it comes to my colleague, good colleague Panos, that is about interpretation of customary international law. It becomes very technical. I'm very thankful that you took the step back and gave the overall picture from the judiciary on how to look at these issues. And I think it's very inspiring to have that view, but at the end, it's also gives some freedom to the courts to work within that space that they have. And you mentioned the word risk at the end, and I would like to follow up on that a little bit. Are there any particular risk reductions strategies that the courts or the judges individually could or should use in order to reduce those risks of taking a too liberal role? Thank you.
Is it okay if we bunch a couple of
Yeah, we
questions?
can, yeah.
Thank you. My name is Larissa van der Herik from Leiden University. So last week I was in Groningen, actually. It's a very active university. And then we had a conference on sanctions, UN sanctions, but also autonomous EU sanctions. And of course, there, the European Court of Justice plays a very important role as a court and really one of the few, or maybe the only court that offers guidance on sanctions principles. So my question to you is, because it's a very particular area of law and it's foreign policy and security policy. So it is quite a difficult role, maybe to navigate for the European Court. So are there particular principles or considerations guiding the European Court in that area? That's one question. And the second is, to what extent can there be maybe a Brussels effect of the case law of the European Court of Justice, in the sense that it may be helpful to identify general principles that should govern sanctions, also those adopted by other actors. So do you see a role for the European Court of Justice in that area that actually goes beyond the European Union as an international actor more broadly? Thank you.
Well, basically, the first question was really how to reduce the risk of activism. Yeah, there are no really, from inside, there are no special, let's say, procedures or rules of the court or rules of the behavior, so to say, for judges or the chambers. At the same time, it is a lot. Of course, it is, a specific experience of a judge, particular area of competence of the judge. I would say the more experienced the composition is, the better. Of course, also, yeah. The good thing is that by nature, the courts, after all, are conservative somehow. I don't know what is in the walls. You go in, you become conservative. I've tried not to, but still, with years, I notice there is a risk of opposite rather than not. So, yeah, what happens is, for example, in the Strasbourg court, and I know that they continue. We started in 2005 a kind of what we called a judicial reflection, informal gathering of the judges, not obligatory, where you pick up on issues and you go around what the reactions in the states are, and I think that type of sensibilization is also through informal, communication is very pertinent, but I fundamentally have a problem with the notion of activism, judicial activism. I don't really see it, actually, because if you approach, human relations, which evolve over time, and you recognize that's just the way it is, that's life. I mean, how can you say that the court, by taking that aboard, is an activist court? You see what I mean? So to begin with, I would have a problem with that. But it's true that there are many factors of cultural factors, sociological factors that come into play. And so I would not see that as a, risk in a sense. But the point I am making, and as it were, I will be making it on Monday as well in the Court of Justice. We have a big gathering of all of the European courts, heads of Supreme Courts and Constitutional Courts, to celebrate 70 years of the Court of Justice. And the point I would like to make, and make it very clear, what matters really is whether you stick to the same backbone of the reasoning from one case to another, and you show that it is as coherent, as consistent as it may be in different circumstances. At the European level, that is really doable, because the convention is there, it's there, you have the backbone on how to apply it. And the Court of Justice, in fact, over the years has managed to, in rather difficult circumstances, has managed to come up with its method. So it is this that should go through as a red thread, through all of and then these risks will be of a different nature for sure, but not of the nature of inconsistency and incoherence, which I think is something precious to work on. So that's how I would see. Okay, now as to the sanctions, well, I mean, for obvious reasons, I will not speak much on that. I hope to be in the composition of the case, because in the General Court, I can simply provide an information. In the General Court in Luxembourg, we have by now quite a number of complaints from certain very rich people of a certain nationality, which are in their opinion suffering from unlawful sanctions. So the European judiciary will really have to deal with that. That's one thing. The other thing is, yes, you're quite right that from the case law, I mean, even going to CADI, there are general principles that are already there, that are available. And speaking of CADI, I would also go back to Strasbourg and say Aldolimi or NADA also provide the principles. And I actually mentioned that when referring to CADI, that of course, the protection of fundamental rights and using the methodology how we assess infringement into fundamental rights, because it's pretty similar, not the same if you look at Article 52 of the Fundamental Rights Charter, but quite similar to what we know in other constitutional orders in Europe. And so the court, in terms of methodology and in terms of principles, will continue along the same line. There is just no other way. Whether there are other considerations such as a fundamental violation of the Jus Cogens rule on prohibition of the use of force, whether that will come into play, that remains to be seen, and how that balances out what we know. But as you see from Western Sahara jurisprudence, application of peremptory norms, because that was invoked in the Western Sahara cases, that is perfectly along the sleeve of the Court of Justice. So yes, we have the elements which will be brought together, and that brings me to your last question on the impact of the Court of Justice, but also the European Court of Human Rights. I mean, what we have seen also how the UN Security Council reacted to the European jurisprudence by trying to sort of put in place some independent assessment to what is included in these lists attached to the Security Council resolution of the people whose assets have to be frozen. Now that really comes, that was impacted by the European jurisprudence. Of course, that leads us into the whole new big issue, you know, of the universality and how justified it is for Europe, for example, which does set high standards of governance and fundamental rights, you know, to try to transmit that outside Europe. That, of course, is the big issue that we will leave for next project, the next conference. Thank you.
Are there any further questions? No. So I think everybody's willing to go and continue the discussion over coffee. Join me in thanking again Judge Ziemele for